History of Medical Cannabis. Welcome to the History of Medical Cannabis Law. In this course, you will learn the efforts to reform medical cannabis law, the efforts to stop the reform, the federal legislative efforts, laws enacted to protect states, and patient rights. You'll learn about the federal landmark cases, and lastly, about the current status of medical cannabis laws. In 1981, U.S. Representatives Stuart McKinney and Newt Gingrich co-sponsored the first of a succession of bills to support the therapeutic use of cannabis. The bills would allow cannabis to be provided to patients with serious illnesses and ensure that they have access to adequate supplies. Specifically, the legislation would require the Secretary of the Department of Health and Human Services to maintain a supply of cannabis to meet the medical, research, scientific, and export needs of the United States. The bills were referred to committee, with no further action taken and no medical cannabis legislation introduced in Congress for a decade. It was a death by committee for the bills. In 1996, voters in California made it the first state to authorize the use of cannabis for medical purposes, in accordance with a physician's recommendation. Voters in Arizona approved a similar measure that year, but problems with the wording of the initiative prevented it from being implemented. In 1998, voters in Oregon, Alaska, and Washington followed suit and passed similar medical cannabis laws. The adoption of these laws fascinated national media. The heightened press coverage prompted Congress to take action to undermine the reform. In fact, the first pieces of legislation introduced during the 105th Congress sought to penalize individuals participating in state reforms. During the fall of 1998, the U.S. House of Representatives debated and passed a resolution expressing the sense of Congress. The resolution states that marijuana is a dangerous and addictive drug and should not be legalized for medicinal use. No action was taken by the U.S. Senate, but the language was incorporated into the fiscal year 1999 omnibus appropriations legislation. A separate amendment to the same legislation instructed that the District of Columbia could not include medical cannabis on its ballot. The amendment was successfully challenged, and 69% of voters in the nation's capital approved the measure. However, Congress blocked the implementation of the D.C. initiative until 2010, and it took until 2012 for distribution centers to be approved. Within weeks of the terrorist attacks on September 11, 2001, dozens of federal drug enforcement agents raided and closed the West Hollywood-based Los Angeles Cannabis Resource Center. The LACRC, a nonprofit agency, was legal under state law and operated with the full support of local elected officials and law enforcement. Despite this fact, federal agents seized the cannabis plants, business documents, bank accounts, and approximately 3,000 confidential medical records. This action left nearly 1,000 patients suffering from AIDS, cancer, and other terminal illnesses without a source for their medical cannabis. In 2003, in an effort designed to put scarce law enforcement resources to better use, U.S. Representatives Maurice Hinchey and Dana Rohrabacher introduced the first in a succession of bipartisan amendments to the Commerce, Justice, and State CJS Appropriations Bill. These amendments would prohibit the Department of Justice from using appropriated funds to interfere with the implementation of state medical cannabis laws. In 2014 and 2015, Dana Rohrabacher and Sam Farr reintroduced and passed an amendment to the CJS Appropriations Bill. This prohibits the Department of Justice from using appropriated funds to prevent states from implementing their own laws that authorize the use, distribution, possession, or cultivation of medical marijuana. The most recent bill was signed by President Obama on December 18, 2015. The amendment must be passed every year with the fiscal budget. In 2004, 2 patients who had been the target of a DEA raid and had their medical cannabis plants destroyed filed a lawsuit against the Department of Justice in the case of Gonzalez versus Raich. The U.S. Supreme Court ruled that defendants, even when they are operating in accordance with their state's medical marijuana laws, are not allowed to present evidence in a federal court to support their therapeutic use of marijuana. Since the Raich decision, at least 24 individuals have been convicted and sentenced to several years in prison, despite not breaking any local or state laws. Steve McWilliams was a Californian who provided medical cannabis to seriously ill people as a part of a small collective. Mr. McWilliams was arrested and charged in a federal court of law for possession and distribution of marijuana. When brought to trial, McWilliams' lawyers were not allowed to present evidence showing that McWilliams was providing medical marijuana to seriously ill patients. Found guilty, McWilliams took his own life while awaiting his sentencing. In 2005, U.S. Representative Sam Farr introduced the Steve McWilliams Truth in Trials Act to amend the Controlled Substances Act, the CSA. The amendment would allow an affirmative defense for the medical use of cannabis in accordance with the laws of the various states. It also limits the authority of federal agents to seize cannabis authorized for use under state law. The Truth in Trials Act enables individuals facing federal prosecution for marijuana-related offenses to provide evidence during trial that the activities they have engaged in were performed in compliance with their state's duly enacted medical marijuana laws. The Truth in Trials Act is not about the merits of medical cannabis. Instead, the bill would restore fundamental fairness in federal trials concerning the use or provision of marijuana solely for medical purposes and in accordance with state laws. The Truth in Trials bill has yet to pass. Over the past 2 decades, 40 states and the District of Columbia have enacted laws that afford legal protections on individuals who use medical cannabis and the people who provide care to them. However, the federal government has never directly challenged the legitimacy of these laws in court. While the state laws differ from federal law and stand contrary to the claim that cannabis has no accepted medical use, these laws do not directly or positively conflict with federal law so as to trigger a supremacy clause challenge, where the Supreme Court would intervene on a state's ruling. Federal case law maintains that individual federal agencies remain free to enforce federal marijuana laws, even in jurisdictions that have enacted medical cannabis laws. It is with the many federal landmark cases that these laws are slowly being challenged and changed. In 2000, in the wake of state laws authorizing the use of cannabis, in accordance with a recommendation from a physician, federal officials threatened to revoke the prescribing privileges of any physician who provides a recommendation to their patients for medical use. In response, a group of doctors led by AIDS specialist Dr. Marcus Conant filed suit in federal court contending that such a policy violates guarantees to freedom of speech under the First Amendment. The government was enjoined by the U.S. District Court in San Francisco from penalizing physicians who recommend the medical use of cannabis. The ruling states that physicians have a First Amendment right to make recommendations, but may not aid or abet patients in actually obtaining cannabis. On May 14, 2001, the U.S. Supreme Court ruled that the distribution of cannabis for medical necessity could not be used to argue a case in federal court. As a result, an injunction against the Oakland Cannabis Buyers Cooperative was issued by a federal district court, forcing the cooperative to stop distributing medical cannabis. After this ruling and resulting action by the feds, focus was brought to the constitutional limitations on federal authority, which influenced the next round of landmark cases. The Ninth Circuit Court of Appeals ruled in 2002, in the case of Conant versus Walters, that federal authorities could not punish or threaten doctors for recommending cannabis. Doctors can discuss at length the pros and cons of medical cannabis and even recommend it, but physicians are still prohibited from prescribing or dispensing cannabis. In 2006, in the case of U.S. versus Ed Rosenthal, the federal court found Ed Rosenthal guilty of cultivating cannabis, conspiracy to cultivate, and maintaining a place where drugs are manufactured. Members of the jury were not allowed to hear testimony revealing that Rosenthal was deputized by the city of Oakland to grow medical cannabis in line with state laws. After the trial, while jurors publicly recanted their guilty verdict and called for a new trial, Ed Rosenthal's conviction stood. However, the publicity from the jurors caused the judge to only sentence Ed Rosenthal to 1 day time served for his conviction. In 2007, unhappy with the reversal, the Department of Justice re-indicted Rosenthal and added new charges, tax evasion, and money laundering. The prosecution admitted that the new charges were in response to Rosenthal's statements against the government. The charges were dismissed by the court as a form of vindictive prosecution. Prompted by a federal raid that left the cannabis plants of several patients destroyed, 2 patients filed a lawsuit against the Department of Justice in the case of Alberto Gonzalez versus Angel Raich in 2005. The lawsuit sought to bar the Department of Justice from using the Controlled Substances Act in cases where medical cannabis is grown and consumed with no remuneration and entirely within the state laws. The case went to the Supreme Court. The Supreme Court ruled that federal law enforcement officials may prosecute individuals who use medical cannabis even if they cultivate their own cannabis and even if they live in states where it is legal. In essence, the Supreme Court ruled that federal agents could continue to use the Controlled Substances Act to raid and destroy cannabis plants. The decision did not invalidate state laws. Decisions about prosecution are still left to the U.S. attorneys. In 2007, the Ninth Circuit Court of Appeals ruled in the case of McClary Raich versus Gonzalez that McClary Raich could not obtain a preliminary injunction to bar enforcement of the Controlled Substances Act based on a common law medical necessity. Application of the CSA to medical cannabis cultivators and users did not violate substantive due process guarantees. The 10th Amendment does not bar enforcement of the CSA. Despite the unfavorable outcome, the court agreed with Raich and concluded, for now, federal law is blind to the wisdom of a future day when the right to use medical marijuana to alleviate excruciating pain may be deemed fundamental. Although that day has not yet dawned, considering that during the last 10 years, 11 states have legalized the use of medical marijuana, that day may be upon us sooner than expected. In 2007, a federal court subpoenaed the state of Oregon to reveal information about 17 individuals enrolled in the state medical cannabis program. The court found that the subpoena issued by a federal court to prove criminal violations against a medical cannabis clinic was unreasonable, since the government did not have a strong need for the information. Ruling in favor of the subpoena would also cause the state to violate its own laws regarding confidentiality to reveal the information sought, which in addition would deter people from participating in the state's medical cannabis program. Balancing these interests, the court concluded that the subpoena should be squashed. The Compassionate Access, Research Expansion, and Respect States Act, CARES Act of 2015, was introduced in the 114th Congress and is the most comprehensive piece of federal medical marijuana legislation ever introduced in the U.S. Congress. The bipartisan act is sponsored in the Senate by Senator Cory Booker, Senator Rand Paul, and Senator Kirsten Gillibrand, and in the House of Representatives by Representative Steve Cohen and Representative Don Young. The CARES Act makes clear that medical marijuana patients, physicians, caregivers, or the businesses that produce, process, test, or distribute this botanical medicine should not face federal arrest or prosecution in states where such conduct has been declared legal. This important bill will remedy the state-federal conflict over medical marijuana law with far-reaching impacts, including 1. Ending federal interference by allowing states to continue to lead the way on medical marijuana advancements and to expand their programs, establishing clear federal protection for anyone abiding by state law, and creating tax equity for businesses operating under state law regarding IRS Code Section 280E. 2. Rescheduling marijuana, which would mean formally acknowledging that marijuana has an acceptable medical use, allowing state medical marijuana programs to continue to operate independently of federal restrictions, and moving marijuana from Schedule 1 to Schedule 2. But the bill would not prevent the administration from further rescheduling or descheduling marijuana based on available or emerging science. 3. Removing CBD from the Controlled Substances Act, which would remove marijuana derivatives under 0.3% THC from the CSA schedules altogether. Permit the transportation of high CBD seeds, clones, and extracts across state lines. And respect for states that allow for levels above 0.3% THC in their CBD laws. 4. Enabling access to banking services, which would allow anyone in compliance with state law to access critical financial services, prevent the federal government from penalizing marijuana businesses, and eliminate incentives for banks to file suspicious activity reports and discriminate against businesses. 5. Eliminating federal research barriers by removing the two biggest barriers to medical marijuana research in the U.S., exempting medical marijuana from the Public Health Service (PHS) review process, and ending the single-source research materials monopoly by the National Institute of Drug Abuse (NIDA). 6. Ensuring equality for military veterans by authorizing Veterans Health Administration (VHA) doctors to recommend medical marijuana, definitively allowing veterans who rely on the VHA for their health care to become medical marijuana patients in states where it is legal, and allowing veterans to disclose cannabis therapy to the VHA without fear of reprisal. Federal protections are limited to the CJS Amendment and policy guidelines from numerous federal agencies. Medical cannabis bills have been introduced in Congress since 1997. However, no bill has yet been voted on by either house. While possession and use of cannabis is still a federal offense, many states have passed medical marijuana laws that provide, at least on the state level, some protection. Ending prohibition is a long journey, but many, many people have worked hard and continue to work hard to see that it happens.